Hi, and welcome back to NCBA's Coffee Break. I'm your host, Nathan Willner, and this is where we take a few minutes to talk through legal and policy issues that are shaping the creditors' rights in financial services industries. Today, we're getting into privacy law and cybersecurity, and in particular, California requirement that takes effect in 2027. It's not one you hear a lot about yet, but it could have a real impact on how organizations and law firms think about data security, which is why it's worth paying close attention to our conversation today. Really excited. Joining us today is JT Gaietto. JT is co-founder and chief operating officer of ConvergentDS and a longtime cybersecurity and risk management leader with more than 25 years of experience. He's served in executive security roles, including as a CISO, and advises organizations, particularly in financial services and other highly regulated industries, on cybersecurity, privacy, and governance. JT is a CISSP since 2003, holds the forensic security credentials, and currently serves on the board of a credit union as well, bringing both technical and board-level perspective to today's security and regulatory challenges. So, JT, thank you so much for joining us today.
Hey, Nathan, thanks for having me today.
So, to start off, for our listeners who may not be steeped in privacy law, can you explain what in the world is the CCPA and CPRA, and who do they apply to, and why does it matter to our
Sure.
listeners?
Yeah. So first and foremost, I'll got to put the general legal disclaimers out. I'm not a lawyer. I don't play one on TV. But there's some very general items in relation to organizations that have data for California residents. And if you think about the CCPA law itself, it was envisioned shortly after the European Union implemented their GDPR guidelines. And California being, very forward-thinking, if you will, on the regulatory front, mirrored a lot of what the European Union had within their law. And some of the initial requirements were things like making sure you're putting correct disclosures out to consumers, giving the consumer the right to ask what information you're storing on their behalf, as well as giving the consumer if legally viable, for you to remove their data from your systems. So obviously, if you've got a requirement to maintain their data for retention purposes, to comply with any other superseding law or federal guidelines, you're authorized to keep that data. Any other information, for instance, if a consumer came and applied for a loan and was denied that loan, you don't necessarily have to keep their application forms. But for instance, that's just one example. Um,
So, yeah.
Go ahead.
No, so I was going to say that another, thing that some law firms might need to keep in mind as you're saying that is that law firms may have a requirement that their bar but says how long you have to keep files for, which might be another piece of this as well. So you got to look at all the facets that apply to this practice area.
Yeah, that's exactly it. I mean, it's extremely nuanced, and if you had a matrix, if you will, there's going to be a lot of overlap in some places. And one thing that California did do is give organizations the ability to say, okay, I see where this federal guideline or this other particular legal requirement supersedes that. You just have to document it. So that's one of the better parts of the law, if there's a an upside to the situation.
So, as you mentioned, there's a significant CCPA and CPRA security requirement that's taking effect in 2027 that really hasn't gotten much attention in industry or even in conversations about data privacy. So, what is the requirement? Is the first question, and why should we, industry, be focused on that now rather than waiting until the effective date?
Yeah, great question. So the California expanded the requirements on the law, and those expanded requirements start actually in 2026, but there's kind of a tail on it on when organizations need to comply. And some of the things that they've added to the law, and part of it is in response to a few lawsuits. So there was a lawsuit, fairly public lawsuit, where the Walt Disney Corporation was sued underneath the CCPA and lost. And essentially because they were collecting consumer data from a demographic perspective, right? So monitoring things that you watch on, say, like Disney Plus or interactions you have on a website. And a large organization like Disney, um, they've got a myriad of systems where they're collecting that data. And so if a consumer went to them and said, hey, I want you well, consumers did go to them and say, hey, I want you to forget my data. They weren't able to necessarily comply with the law because of just the way that their data was unstructured, right? It just was in so many different places. It was hard for them to certify and guarantee they didn't continue to hold that particular consumer's data.
Hmm.
So there's been a number of those types of lawsuits, and so this appended these added requirements aim to address some of that. The first part being, do you have a data inventory or where all this consumer data is, right? And if you have that inventory, have you tied a criticality to the system that the data is stored in? So, for instance, if a collection firm has a collection platform, and you host that on-prem within your environment, understanding that server that it sits on and where that consumer's data is, and it's a critical location, right? It's critical for you to run your business. Having that inventory is important. The second piece of this cyber regulation they've put in is that a qualified independent cybersecurity assessment has to be completed against all your critical systems and workflows. And so, one of the things that the NCBA has introduced over the last 12 months is the CTS program, this Committed to Security program, that would satisfy the CCPA cybersecurity, independent cybersecurity evaluation of an environment. The other piece that they've folded into this, and that where it kind of goes farther than any other privacy regulation that we've seen thus far, is that it specifically calls out where you've got automatic decision making, right? So if you're using any sort of artificial intelligence to make any sort of business decision based on consumer information that you hold, you also have to fold that technology into that risk assessment because they want to make sure twofold. One, as you're using that data, you're not inadvertently training giving, JT Gaietto's non-public information to a public model like ChatGPT, but they also want to make sure that as you're going through those processes, that you haven't inadvertently introduced some sort of bias in your decision-making rule, right? So if you had something that said, okay, well, I'm trying to figure out the willingness and ability for John Doe to be able to pay, and as part of your decision logic, you say, okay, well, individuals that are in zip code 90210, they must have a high ability to pay. So therefore, because of their demographic and where they live, let's add some inherent bias versus looking, at a whole of this is the consumer, this is their current situation. You have to you can't make broad stroke decisions based on potentially class-based information.
Yeah, so I have some more questions about this, but I want to
Yeah.
just pause a second and ask you about, you mentioned CTS and the program that NCBA has put in place for available for its members. And when you're talking about this kind of level of auditing and knowledge requirement, maybe talk about that for a second. Like, how would that program help a law firm deal with this?
Yeah, great question. So, CTS's initial start, right, was designed to help law firms look at their vendor supply chain and assess the risk that those vendors have to consumers, right? And so, again, if you think about things on the criticality scale, and the way I like to always define that is what vendors and what processes do you have in your business that if they were shut off tomorrow would shut your cash register, right? So that's litmus test one on criticality. litmus test two, then you start thinking about the types of interactions a vendor might have. Are they talking to consumers on your behalf? Are they going through consumer data, but in a scripted manner? Or do they have unfettered access to your consumers once you turn it over, right? So that's another area of criticality that you look at. And so CTS is designed to take all those elements and apply it against a common security framework. We've used the SCF model, which is an open source framework that has been cross-mapped to a myriad of different organizations, including California's privacy requirements, NYDFS for New York, the NIST standards, PCI, you name it, right? It's been cross-mapped, and the beauty of it being open source, as new iterations of these different control frameworks get updated, the open source project also gets updated. So that allows us to feed CTS additional controls as they evolve. One of the big pieces that we added this year was I think it was about a dozen and a half additional control questions around AI because AI has become a very big topic. And so ways law firms could benefit from this is twofold. One, if a law firm feels that they're subject to CCPA and the privacy requirements, they could adopt going through the CTS program themselves. Several law firms have done that already. And that would give them, the information they need, not only to improve their security, but also to meet these privacy and regulatory requirements. And then similarly, for members that don't already, that aren't necessarily subject to CCPA, the goal of the program is to help them at least answer 80% of their control questions that they have over their vendors. For instance, some law firms might have some additional questions they want to ask either because their clients upstream have asked those, ask them to ask those questions of their, quote unquote, fourth party vendors. And through the platform, which is for CTS, which we call Sanctum, those law firms can actually, if we start seeing a commonality, we can expand those custom questions into the vendor risk assessments as well. So overall, it's a dynamic program, but it's designed to help meet a number of these regulatory requirements as well as be expanded on as they evolve, like we've seen here with California.
And while I'm sure there's companies that do this kind of thing, there aren't any companies I know of that really understand our practice area and are familiar with the kind of work our law firms are doing. Because if you go to someone who thinks they know law firms, that isn't
Right.
our kind of law firm. And if you're going to someone who thinks they know financial services, that's not a match either. So, it's really important for, people to take a good look at what you're offering because it's going to, in my opinion, save a lot of grief of explaining and catching things that maybe you'll miss because you're not familiar with the practice area. So keeping that in mind, and this is also an important thing I think that we should mention because we're talking about California. We have people listening from all over the country. Why would they care about one state if they're not located in California? So maybe you can explain that it's a California law, but how does it apply to the industry at large?
Yeah, and there's kind of two different thresholds. There's a financial threshold, right? And it's somewhere right around revenues in 2026 in essentially over $26 million, right? Or holding sensitive information of 50,000 50,000 contacts or more for someone that lives in the state of California. So you've got these two different thresholds, and it's an either or. It's not an and, is my understanding. And so if you're processing that high level of consumer data, and it's not looking at that on an annualized basis either, right? So for instance, for a law firm that's been in business for a very long time, odds are you probably do have 50,000 records in your system, or more. And so even if you're not located in the state of California, it behooves you to go through and do an inventory review of the data records you do hold to see how many of consumers you have in California, And if you're meeting those thresholds, because irregardless if you're physically in the state or not, the rules do apply to you because you're dealing with consumers in California.
Yeah. And you're right that some law firms that have been in practice for, 10 years, 20 years could have inventory, especially when judgments, depending on the state, judgments are good 10, 20 years. And it's very
Yeah.
likely that you have those judgments sitting in your inventory. You may not think about that as being part of what the active, resources that you're working on, but they're in your inventory and you'll have that. And
Right.
people move around. It could be people that were in California that weren't and now are. So there's a lot here to unpack. So thinking about it that way, what best practices are emerging for meeting this 2027 security requirement? How should law firms, NCBA members, be thinking about aligning privacy, cybersecurity, vendor management efforts, especially when those functions often sit in different parts of the organization, and may not be readily thought of as one pocket of information?
Yeah, and building even further than that, smaller law firms might not even have someone dedicated full time to any one of those areas, right? So it's not only different individuals in an organization, but it might be a fraction of a certain individual's time. So that it's a complex problem. But the first place that I always like to laugh, it's like eating an elephant. You just got to do it one bite at a time. And so starting out, the best thing to do is really take a full inventory of your data assets. And I know that seems like a broad statement, but the data assets, your information systems, right? So we've got X number of workstations. These are the types of softwares we need to use to run our business. These are the dialers that we utilize to do outbound calling, if that's applicable to your organization. These are the systems we use to file judgments with different jurisdictions across the country. And then likewise, your database, right? Your inventory is that crown jewel of your organization, and going through and having doing a statistical analysis of how many consumers do we have by state, and seeing if you hit these thresholds, because that's the critical starting point on what data do we have and how do we use that data to run our business. And once you have that, that also gives you the leaping off point for doing your vendor due diligence, right? So if you know what systems are critical and what softwares you're using, or services and software that you're using to do that, that gives you the list of third-party vendors that you need to go and do due diligence on. And likewise, I think, organizations we've helped go through this process, because it really should be done at least annually. More and more we're finding folks discover that there are things that their employees are utilizing that they weren't aware of, right? So AI chatbots are a great example of this. Especially for anybody that's doing a lot of business intelligence or data aggregation and manipulation. Odds are, someone's probably using an AI tool to help themselves with that, because it's really good at doing that, right? So that's it's better than manually sitting there moving a bunch of stuff around in Excel. But the organization as a whole might not be aware that that tool is being used, or where we've seen kind of what I'll call shadow AI, employees are just paying for it themselves and expensing it. If they can expense it, they'll throw it on an expense report.
Huh.
Well, of course, the people in accounts payable aren't thinking, well, this other person within the organization should be aware that this tool is being used. They just pay the $20 or
Yeah.
$40 or whatever it is and move on. So
You know,
yeah,
I also wonder if as AI is literally creeping into every corner of technology, it's possible that you have a management platform that you're using already that they're updating with new technology, that the platform's company is throwing AI into different parts of it that you may not even know yourself, that you may not even
yeah.
understand exactly how it works. And that takes someone like with your expertise to kind of say, oh, that they added this thing in here, because when you updated the program, that may have been dumped in and you won't be aware of it till till
And one,
till someone else finds it.
yeah, and one guaranteed software that I would argue is probably prevalent across almost every law firm is Adobe Acrobat. So, we deal with PDFs all the time, right? And so,
Hmm.
one of the things that a lot of folks are surprised to hear is that the latest versions of Adobe's productivity suite, including Acrobat, has built-in cloud-enabled AI that, by the way, you can't shut off. And that's by design. So they want to learn how you're using the tool, what kind of content's going through the tool. So that's just one simple example.
Yeah.
But it's more prevalent, to your point, Nathan, than I think a lot of people think about, right? Because it's there, and many companies. I think I was just talking with another CISO in the financial services space, and his board has put an edict out that everyone in the company needs to spend at least 2 hours finding 2 hours a week to build either an AI agent or to do something AI related to increase productivity and report on it on a monthly basis with the goal, and they're setting goals for each department to increase productivity and cut costs. And that's a interesting, edict, but they're not really putting any guardrails on it. They're just saying, go forth and do this. Right? And that's where they're going to have some potential challenge, right? Is that somebody's going to get smart and say, oh, hey, I've got OpenClaw, which is a open source AI agentic agent, right? So you basically tell it what you want it to do, and it'll start doing it by itself. Um, and for folks that aren't familiar with it, it's like giving full admin rights to your organization to an intern that can't get your coffee order right. Right. I mean,
And
that's the
yeah,
scope of the risk.
and in this space, if you do it once and it's wrong, you've done it already 1,000 times wrong before you get it to stop it. And
Right.
that is, brings me to my next question. Finally, let's talk about risk. How could this
Yeah.
2027 requirement change the way regulators or plaintiffs evaluate what counts as reasonable security? And what are some of the most common missteps you're seeing today that could create real exposure down the line?
Yeah. So there's a couple, I think a lot of folks are, again, overwhelmed because of the pace that AI is changing, right? And so it's real easy to feel like, oh, I wake up every morning, I see a different headline, and the headline includes AI, right? And that becomes a piece of just a data point that feels overwhelming. And the reality of it is that everybody's boat is already crashing underneath the waves, right? And we're all busy trying to bail out. So this thing is evolving quite rapidly. But um, you know, a lot of the traditional fundamental best practices still apply here. And so the first one, and I know I've said it quite a bit, is know what to understand the level of risk you have, you've got to know what you've got, right? And so having those inventories is really important. And one of the most common missteps that we're seeing is that, I'll give you another example. We've got another client we were working with, and they've got a tremendous amount of legacy hardware in their environment. They've kind of put off uh, desktop upgrades and server upgrades for a long time. And they've now gotten to a point where they've got a very large financial burden to rectify all of that, right? And so, in order to understand that risk, I said, well, let's get a full inventory. Then let's start picking at the very critical points within that infrastructure because you can't afford not to. And then when you start looking at something like CCPA, where it says, well, you've got to do this annual cybersecurity risk piece, and then starting in 2028, you need to go online. An officer of the company's got to go online and certify that they've been doing these things, right? So at the risk of purging themselves to the state, they've got to, sign on the dotted line, and they got to do that on an annual basis. And so in order to understand your risk, you got to have those fundamentals. You got to have an inventory, got to know what you're dealing with, evaluate that. And then likewise with the AI pieces that are coming in, um, just because it's AI, you still should think about using what we call the principles of least privilege. Don't give the AI any more access than it truly needs to do the task at hand. Similarly, like don't tell your employees to do something with AI farther than what you're trying to get them to accomplish. Those are some of the two big missteps that we're seeing in the space right now. And once you get your handle on what's out there, right? It's a lot easier to address, because you're able to prioritize and triage your risk factors.
Yeah, so we're getting close to the end of our cup of coffee, so to speak. And
Yeah,
this was really very, very useful information. It's been incredibly helpful. Just I talk about this industry every day, all day, and this is information that is so specific that you can't get it anywhere else. And this is great program that NCBA is offering our members. That you should really take advantage of it because I think it'll keep people out of trouble. So with that, thanks for breaking down this issue. A lot of organizations may not realize that it's coming much faster. It's here. I don't know if it's coming
yeah.
faster. It's here already. And thanks to our listeners for taking a few minutes to join us today. These coffee breaks and the information that professionals like yourself share is really invaluable. And thanks for our listeners for taking a few minutes to join us for this coffee break. So until next time, listeners, stay curious, stay prepared, and most importantly, stay caffeinated. We'll see everyone soon. Have a
All
great
right.
day.
Thank you.